To say you don't have this in your pack because I wasn't sure if PowerPoints were required, and then I discovered that everybody else was having them, so I'd better do one. I came here to give people a dire warning about deprivation of liberty safeguards. First, can I say it's a great pleasure to be here. It's always lovely to come to Galway and meet old friends, particularly Mary and Siobhan and everybody. It's a great place to come to have your thinking challenged and just generally to feel warm about lots of colleagues. So thank you for inviting me, and thanks to Amnesty International, Amnesty Ireland, who in my view are doing the most of all amnesty groups in the world for mental health rights, and for that congratulations. Basically, what I want to do is talk a bit about rights-based mental health law and a bit about the English response to a human rights case called HL in the United Kingdom, where a man who was deemed to lack mental capacity to consent to admission to hospital was taken to a psychiatric, a learning disability hospital, was kept there. His carers, who have been looking after him for years, were told not to come and see him. He eventually, his case went to the European Court of Human Rights, which held that there had been a breach of Article 5 of the European Convention. Now, this is the old rights paradigm. The new rights paradigm is the UN Convention on the Rights of Persons with Disabilities. The old human rights paradigm, which many of us were glad to have in years gone by, is the European Convention on Human Rights, because it was the European Convention which laid down the criteria about detention on grounds of unsoundness of mind, which said you had to have objective medical evidence of a true mental disorder before you could detain somebody. And why that was important was because at the time there were massive abuses of psychiatry going on in places like the Soviet Union, where people were being detained on grounds of mental ill health simply because they disagreed with the regime. And so that old paradigm had its place. And in this case, in HL's case, HL managed eventually to secure his release because he had been kept in this hospital, kept away from his carers under such a degree of control that it amounted to a deprivation of his liberty. And because he'd been deprived of his liberty without following a procedure prescribed by law, that was a breach of his human rights under the Convention. So there you have a situation where one human rights paradigm, if you want to call it that, says that you can only be detained, deprived of your liberty on grounds of mental ill health if there is objective medical evidence of a true mental disorder. And so if we just sort of move along here, what I'm worried about is with mental health law is what I've called juridification, which is a fancy word, but really what it means just is there's a lot more law about this. There is a lot more law about mental health detention, mental health treatment, mental capacity, and all the rest of it. And so Habermas talks about is the expansion of law into hitherto informally regulated social matters. That's what happened to Mr. HL. He was taken away to hospital. It wasn't regulated. The European Court of Human Rights said it had to be regulated. And so we then had regulation. And it's the regulation I'm going to talk about in a moment. But what Habermas also says is just because there's more law doesn't mean there's more freedom. It doesn't mean there's more rights. And what we got in England and Wales in order to implement this judgment was the most horrendously complicated piece of legislation you have ever seen in your life. One power to deprive mentally incapacitated people of their liberty ran to 153 clauses in the Mental Capacity Act. Now let me just tell you what happened as a result of this case. HL was restored to his carers. He now lives there happily. I get Christmas cards from them every year with pictures of how he's getting on. But as a result of his case, a new set of safeguards was introduced called the Deprivation of Liberty Safeguards. And those safeguards were introduced not under the Mental Health Act, but under the Mental Capacity Act. Why was that? Well, the groups who were most likely to be deprived of their liberty when they didn't have capacity to consent to go into hospital were people with intellectual disabilities and people with mental illnesses of old age. And the lobby groups on behalf of both of those groups were adamant that they didn't want their loved ones to be detained under mental health legislation. They were quite happy for them to be deprived of their liberty, to be placed in institutions, care homes or hospitals, as long as it wasn't under mental health legislation, because that's stigmatizing. And so what we had in 2007, the British Parliament, the UK Parliament, introduced a new statute in England and Wales, a reform of the Mental Health Act. And in that reform was a set of provisions which were going to amend the Mental Capacity Act of 2005. And that, those proposals did not receive one word of parliamentary debate. You will look in vain in Hansard to find anybody saying anything about these deprivation of liberty safeguards. They said everything about all the Mental Health Act reforms, but the victory, as far as everybody was concerned, had been won. We've got our loved ones out of the Mental Health Act and into the Mental Capacity Act. Phew. I was working at the time for the Joint Committee on Human Rights, and I said these safeguards are not going to work. And you may think this is just sour grapes, this is Fennell coming back, fighting a battle that he's already lost 25 times. But I am going to be proved right at some point, and I was very glad to see that the proposals of the interim report, which arrived in my possession very late last night, say that you're not going to go down the same route as the English have gone down in relation to deprivation of liberty safeguards. You're going to use adult guardianship, which itself will probably raise some hackles amongst people who are keen on seeing the kind of implementation that the committee has advocated in Tunisia of Article 12. But, basically, we've got two human rights paradigms now. We've got the European Convention, which I've mentioned. The only way you can detain somebody under the Convention who hasn't committed a crime or isn't being arrested for committing a crime is on one of these grounds in Article 5.1e, which are very, they lump together all kinds of different groups of people, including vagrancy, unsoundness of mind, and addiction, and communication of infectious diseases. So you can detain all these people without them having done anything wrong. And that's the only, if you're detaining somebody on grounds of unsoundness of mind, there must be objective medical evidence. Article 14 of the CRPD says, well, if it doesn't actually say this, but all the kind of interpretive declarations around it say you've got to get rid of mental health legislation altogether. You can have preventive detention, but it's got to be delinked from disability. which includes psychosocial disability or mental disorder. So right there's a paradigm clash. Countries like the UK and Ireland, which follow the European Convention on Human Rights, and also England has signed up to the convention and has recognised the right of individual petition, are going to have a conflict to deal with between, which human rights conventions are we going to be complying with? And I'm going to suggest possible ways out of this. But what the British government did was they introduced these things called the Deprivation of Liberty safeguards. And the Court of Human Rights said deprivation of liberty is it has to be distinguished from restrictions on liberty which don't fall within Article 5, and you have to look at the concrete situation of the individual. So it's not just an issue of law, it's an issue of fact. What is the type of the interference? What's the duration? What are the effects? What are the manner and implementation of the measure in question? Now, the way the British government tried to solve this was by saying, we will have this set of safeguards where we will leave it to the care home or the hospital to assess the situation and decide whether they're depriving somebody of their liberty. And if they are, then the person will be entitled to all these safeguards. You can imagine what the British courts have done with this and what the British legal profession have done with this. What is the type? What's the duration? What are the effects? So the whole thing has become highly technical. So technical that we have had about 20 cases on what a deprivation of liberty is. Not just in the context of health and social care, but in the context of anti-terrorism legislation. Is a control order where somebody's subject to an 18-hour curfew a deprivation of liberty? And then that case law comes across into the mental health arena. And then what happens is we are now saying to proprietors of residential care homes and people working in hospitals, you've got to make this legal calculation. You've got to decide, before anybody gets these safeguards, whether they're being deprived of their liberty. And the result of that has been that the safeguards are introduced, a procedure is introduced whereby we have to do assessments. We assess the person whether they are over 18, whether they've got a mental disorder, whether they lack capacity, whether it's in their best interest that they should be detained. Are they eligible? Are there any objections from people entitled to object? And then when we've done that assessment, we can grant a standard authorization to authorize deprivation of liberty for up to 12 months. And that all depends on this person in charge of a care home deciding whether somebody's been deprived of their liberty. And what has happened in England and Wales is that the regional variations in the use of this procedure are dramatic. Some areas don't use it at all, other areas use it a lot. And we have also seen the arrival of these new people called Deprivation of Liberty Coordinators, a title straight out of George Orwell, where the supervisory authority has somebody who coordinates the deprivations of liberty procedures in their area. So the whole thing has become slightly unwieldy, or greatly unwieldy. I'm going to zoom past a load of slides here and just tell you very quickly what's happened. There are three ways of depriving somebody of their liberty under the Mental Capacity Act. One is by the Court of Protection doing it. The other way is by using these procedures which I've mentioned, which is less cumbersome than going to the Court of Protection. And the other is an emergency deprivation where it's necessary to save life or prevent serious deterioration in the person's condition. But if you're not going to be deprived of your liberty in a care home or a hospital, it has to go to court. The Court of Protection must do it. And of course, judges and lawyers think this is the absolute pinnacle of legal safeguards, a good old court hearing. 50 grand in disbursements, and plenty of time in court. So that's the second. But the courts actually don't want to be dealing with many of these cases because they are lengthy, they are cumbersome. They don't want, as we lawyers say, to open the floodgates. So it's in their interest to say that very few things are a deprivation of liberty. And this is where we come to the convention point. Because what has happened is that there have been a number of cases where it has been alleged by social workers usually who've come in to support you, and they say, well, it looks like you might be depriving your loved one of their liberty. Better go to the Court of Protection. So two families who are having to lock their loved ones in their bedrooms at night because they've got Smith-Magenis syndrome, and they wander and escape and eat things that they shouldn't eat in the middle of the night, things that might poison them. They've locked them in their bedroom. Is that a deprivation of liberty? And the courts have said, no, it's not a deprivation of liberty. But the most dramatic of these has come most recently, and I'll just tell you about it because this is the case of Cheshire West. And this is where I think the English courts have made a big mistake in terms of the UN Declaration. Or convention, sorry. This man, 39-year-old guy with significant physical and learning disabilities, he's living in a house which isn't a care home. He's got a long history of pulling at his continence pads. He puts the pieces of padding in his mouth and on occasion eats them. So he's got to be under very close supervision. He's got to live in this home, and he's got to wear this special suit to stop him from eating these things inappropriately. So it looks like there's a very intense degree of control over his movement, his treatment, his residence, and all the rest of it. Is he deprived of his liberty? No, he's not. Because Lord Justice Munby looks at an old human rights case called Engel and Others against the Netherlands, and he said, what you've got to do when you're deciding this is you've got to decide, when you're looking at whether somebody's deprived of their liberty, what their normal situation would be. You've got to compare them with what the normal situation of somebody in that position would be. So in Engel, the Court of Human Rights said these people were soldiers who were confined to barracks, so there wasn't much difference between their life as soldiers and their life in the situation of being confined to barracks. So that wasn't a deprivation of liberty. Can you see where this is going? So what Munby then says is, in the case of an adult with disabilities, the relevant comparator is an adult of similar age with the same capabilities, affected by the same condition or suffering the same inherent mental and physical disabilities and limitations. Some people are inherently restricted by their circumstances, and the normality with which we are here concerned is the normality of the life of someone with the relevant condition, not the normality of the dreaded able-bodied man or woman on the Clapham omnibus, revered by the English judiciary. So what are we talking? What are we saying here now? We're saying that if you're already, your life has been limited by your disability, that's what's depriving you of your liberty, not the state. So where does that actually take us? So what he says is, when evaluating and assessing the relative normality of X's concrete situation, the contrast is not with a previous life led by X or with some future life he might lead, but with the life, not with the life of the able-bodied man on the Clapham omnibus, notice it's a man, but with the kind of lives that people like X would normally expect to lead. Now, this is one of our most humane judges too. In terms of his other judgments on the rights of persons who lack capacity. But what you see here is something which is a clear, in my view, breach of Article 14 of the Convention on the Rights of Persons with Disability, because that says people who have disabilities have the same entitlement to the same protection against deprivation of liberty as everybody else. And if your protection depends upon whether some scientist decides that you've been deprived of your liberty or not, and that person says you're not deprived of your liberty if you're profoundly disabled because it's not the state that's doing it, it's the disability that's doing it. I mean, it just, well, you know, I mean, I expect you even to shoot me for telling you this, even though it's not my idea. It must be a breach. So, I mean, this is what he says. In the end, he says you've got to have a comparator, and so you compare the person with the situation that they would be in if they were living somewhere else. So, if you know, take an example. If I've got somebody living in my house who I have to assist with feeding and control quite a lot of their life, and they're then taken into an institution, they're not deprived of their liberty because they would have been having that at home anyway. So where does that leave us with mental health detention? And this is what I think is most stark about all of this, is that when we talk about detention under mental health legislation, the people doing the detaining aren't going around with their faces sicklied o'er with a pale cast of thought, saying, is this the deprivation of liberty or is it not? We're taking this person to hospital, we'll stop them from leaving if they try to leave, and end of story. We're sectioning them under the Mental Health Act. But when it comes to this situation, we're saying, is this a deprivation of liberty? We're subjecting it to minute examination. And of course, once you let lawyers and courts in England loose on this kind of thing, they will find every nuanced little reason for finding that somebody is not deprived of their liberty. And the safeguards will not apply to them. And if the language is different. The language of the Mental Health Act says that patients are liable to be detained. The language of the Mental Capacity Act is a person is eligible for the deprivation of liberty safeguards. So it's like some, we were talking last night about, what a big influence religion has on the way we think about things in Ireland. And this is like, some sacrament that is going to be bestowed upon you, that you're now eligible for you're not going to be detained, you're going to be eligible for the deprivation of liberty safeguards. And they aren't safeguards. That's the other thing. They're not as good, if you're talking about procedural safeguards, they're not as good as the Mental Health Act safeguards. I'm glad to see that you're not going down this route. But the other thing that I think is very important to remember when we're looking at mental health law is that there's a lot of it about. And it is becoming increasingly dense and impenetrable. And this is what a judge said in Blackburn and Darwin case. We're running a conference in Manchester where this judge is going to be speaking. He says it's a truly unhappy state of affairs that the law governing the fundamental rights and welfare of incapacitated people should be so complex. Its intricacies challenge the understanding of professionals working in the field. How can people who care for even, not let alone people who are suffering from a psychosocial disability, how can they understand these complex legal concepts? And I think it behoves all of us who are involved in this to think, how can we make these laws accessible to the people who they're supposed to be giving rights to? It's all very well to talk about rights-based legislation, but if you need to have some genius to tell you what your rights are. I mean, we have this, I'm a member of a carers group, and I spend most of my time talking to people about, they say, well, look, we've seen this. They told us these were our rights, but we haven't a clue what this means. Tell us what it means. How do we get this? And that is the crucial thing, is to bear in mind, is that, you know, you need law in this area, as in pretty well any other area really, which is not so highly technical that the people who get the rights can't understand what they are. So I seriously doubt, and seriously doubt it means I firmly believe that this comparator approach is not compatible with Article 14 of the Convention. Even if we don't adopt this paradigm shift approach where we say, you know, forget about Article 5, let's move over totally to Article 14, if we say that somebody is less entitled to the protection of Article 5 because their disability has already deprived them of their liberty, that is the way that I think Article 14 will go before we get to a paradigm shift situation is that courts will start using Article 14 as an aid to construction of Article 5 of the Convention. That's what they'll be doing in Europe. Tunisia is a different case because it's not a party to the Convention. We need to avoid this congested legal landscape issue. And the final issue is, are there ways in which it may be compatible with the CRPD to use adult guardianship? And I'm about to go away and read this 600-page blockbuster that Bernadette has told us about. Is substituted decision-making permissible as a last resort? I think it is. There's a very good article in the book, the Rethinking Mental Health Law book that Bernadette mentioned, by Annegret Kamp, who's one of Bernadette's colleagues at Monash, about this. And I think, you know, these things need to be really looked at closely. I don't think adult guardianship, I am very much against plenary guardianship of the kind of European model where people lose capacity to do anything. The kind of Shtukaturov and Russia kind of situation. But I do think there is some place for thinking, if we're going to accept that people do need to go involuntarily into very close care in institutions, there's some place for thinking, how can we do this in a way which doesn't infringe individual rights, which doesn't infringe individual dignity, and which doesn't depersonify people in the way that everybody is so evocatively talked about. That you know, you can still treat somebody as a person even though you're protecting them. You can still recognize their dignity and their rights even though you may have to override their wishes in particular, or the way they're expressing their wishes at the time. But I stand to be shot down on that point. But I stick to my guns on the Article 14 and Article 5 point. Thanks for listening.